Good afternoon, everyone.
Good afternoon, Miss Bridgewater. I don't think I've ever seen your face before.
You've been missing this face?
I've been missing that face. I mean, all that time I did SAP, send you all those documents. That's the first time I think I've seen your
Oh, wow. How about that?
face. Yeah, to tell you what, I've been missing out too.
How kind of you.
Yeah. Well, I'm here today. I see you, Miss Kim. How you doing, Miss Kim?
I'm doing good. How are you?
I'm good. Thank you for sending all the information out. Our internet, well, no, not internet, but our email is down. I don't know if anybody else is having that problem. Mine is.
I
do. Yep, everybody.
So I don't have a calendar. So.
Oh.
Me either. I try to get it from the chat, and even though I scroll up, I don't see any link.
Really, that's going to be a problem. Let me see what I can do.
Okay.
Thank you.
Thank you.
So the calendar was placed in the chat. If you click the chat button, you will see the calendar document in there. You have to download the document to your computer in order to open it. But you have to click on chat in order to see the document. You're muted, we can't hear you.
I went to the chat, but I don't see any link.
She said she went to the chat, but she don't see any
She
link.
may have joined. A lot of
So it's
people
not a
just
link, it's a
joined.
document.
No, even if you just joined, I just reposted it.
So you should see a document under the chat that was sent by Fulton County State Court. And you can download that document to your computer.
You're on mute, Mr. Ford. I don't hear nothing. Is it me?
She won't.
Is this process just for today, or will it be foregoing as it relates to the calendar?
I believe this is just for today, Ms. Mann. They're experiencing some problems with the emails.
Okay. Okay. Thank you.
You're welcome. Mr. Ford, did you see the document?
Okay, I saw the document, but I tried to download it to, I'm not on my Fulton County computer. So that
You don't have to be on your Fulton County computer.
Then you have to walk me through. It says I clicked on it and it says save. It says SEA 29 in my file name. And do I have to save it somewhere? It just says save.
Save it to your desktop.
And then it's gonna open.
Save it to your desktop. Click desktop, save it there, and then minimize everything and click so you can just see your main home screen, and you should see the document name pop up on there.
Okay, let me minimize then. All right, hold on. Won't let me minimize, but as long as I got this open. So you said,
yeah, you have to save it to your desktop. Click desktop.
Okay, okay, there we go.
And then press save.
Okay.
Now minimize everything.
Minimize.
Do you see the document name?
Let me hold on. One more time. Is it going to be in my files or where is it going to be?
It should just be on your desktop, your main desktop screen. You should look for the name titled, I think it's titled 29.
All I have to do is look, right? I see it.
Right. It should say SEA. It should be a Word document.
Yep.
Do you see it?
It's opening now. Thank you so much.
You're so totally welcome.
Yep, I'll be able to print that out.
I'm sorry, but I cannot do it. I don't see any link from my iPhone. Maybe do I have to do it with my computer phone? I mean, computer Zoom.
It wasn't a link. It was just a file attachment from the chat. So the
Okay.
link is how can I say this? It's the file download. So you have to actually save it to a drive on your computer. The easiest way to save it is on your desktop. So scroll through your chat, click that little asterisk with the blue around it that has the downward asterisk. Click that, or click where it says click to download, double click it, save it to your desktop, and then clear everything off, minimize all your screens, and you should see it on your desktop.
You know how excited I am that I did something for the first time, right?
Hello.
Hello?
Hey, oh, this is Mia Jackson. I don't know, but if I'm doing this right.
Thank
This
you
is
so
Mia
much.
Jackson joining in.
Miss Jackson, we're waiting for the court to start.
Oh,
So
okay.
just keep your phone on mute and your camera off unless you're called by one of the court officers or a member of the court.
Oh, okay.
Yes,
I was just
ma'am.
making sure I was in. Thank you.
Yes, ma'am. You're welcome.
Thank you so much, Miss Bridgewater. I was excited to do something for the first time, you know, to get that downloaded like that.
Babe, you don't have me to thank because I'm so confused today.
All right. But I did it.
But
I
I'm so
did it though.
confused.
I did it. Thank you so much. I have the calendar now.
Okay.
Oh, that's all right.
Yes, sir.
I was just about to ask you what's going on. So yeah, y'all seen that?
Yes, hopefully we
Okay, never
can.
mind.
All right, hold on one quick second.
Ms. Coleman, please have a seat right here for me.
All right, good afternoon, everyone. Is everyone ready? I know we've had some technical difficulties today on all ends. So I think we're all together now. Are we ready?
I
Yes,
believe
Your
so,
Honor.
Judge.
Yes, Your Honor. Good afternoon.
Good afternoon. How are you?
Good.
All right, ladies and gentlemen, good afternoon. This is the State Expedited Accusations Calendar. I am Judge Regina Mincy, and we're going to hear cases for individuals where you have been recently arrested and charged with certain misdemeanor offenses. Soon after your arrest, the Fulton County Solicitor General's office has already accused a case, and they have been bound over to the State Court of Fulton County. Nevertheless, this will usually be your first or initial appearance before a state court judge, so we can address several matters today, including bond, possible arraignment, or consideration of a possible plea offer if one has been made by the state at this juncture. I will also be providing you with a reset date for SAP And what is that date, Ms. Bridgewater?
February the 22nd.
Okay, February 22nd, 2022. It's a bunch of
All
twos.
twos.
All twos, okay.
Mhm.
All right, good. And so you will know that as your date if we tell you. I'm going to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I also want to make you aware that you do have a constitutional right to remain silent. Anything that you say about the facts or occurrences of your case can and will be held against you. So everyone is represented either by the PD's office or by private counsel. So please defer and listen to your counsel before speaking or asking any questions, because it may be something that will be against your interest. Also, and I think that's it. So we'll go ahead and get started. I see South Annex.
Yes, Your Honor, good afternoon. We started with position number 11, Ms. Corman.
Can you
Okay.
explain when my parents are on the call?
Let's see, do we have anyone with the Corman case?
Yes, that's me, Your Honor.
Okay, she's asking if her parents are on. Do we see
They
any
are.
witnesses?
I don't,
Okay, I think I see Peter Corman. Okay, all right, I see your parents there, Ms. Corman. All right, I will get to them. Let me call the case first. This is case number 22 CR 000-652E, State versus Haley Jordan Corman. You're charged with one count of obstruction of law enforcement officer and another count of violating a family violence protective order, both with the offense date of February the 8th, 2022. Do I have anything pre-trial?
Yes, you do. Check your chat real quick.
Okay, hold on a second. Okay,
All right, 35 total. She has history out of California and Georgia.
That's incorrect.
hold on, Miss Corman, we're gonna mute you because you don't need to talk right now with the presentation of evidence, and you need to defer to your attorney, Mr. Ford. But we're gonna mute you for right now because this is not your time to talk, okay? All right, go ahead, pre-trial.
Last arrest was back in December for simple battery. So that's open. That's 21 CR 007-352E as in Edward. That's an open simple battery against police, law enforcement, obstruction, and another simple battery. That case number is 21 CR 006-822E as in Edward. She's on probation for exploit, inflict pain. That's from 2019. She got a 3-year sentence for that. 19 SC 166794. It's exploit, inflict pain on disabled person or elder person. There's most of the history is violence. She got convictions out of California. That's a lot of them.
That's
So,
fine.
yeah.
All right, that is good. I get the gist of it. Thank you.
Your Honor, the state would like to request a breakout room on this case.
All right,
I was wondering if that was coming.
good. Yes. All right, hold on a second. We'll be in a breakout in a minute. I will come back to you, Mr. and Ms. Corman.
Did you ask for a breakout room, Judge?
Oh, yes. Is that Natalia?
Yes, it is.
Okay.
Who's
I
all
was
going
already
to
say Mr. Jordan, so I apologize.
Okay.
So that
Who
will
we have?
be Mr. Walker, Mr. Ford. And is that it for you, Mr. Walker? You don't have anybody else with you?
Miss Mitchell.
Yes.
Oh, Miss Mitchell.
I asked that Miss Kim be added to this as well.
Okay.
Walker, Ford,
Kim and Mitchell.
Kim,
Uh-huh.
Mitchell.
Yes.
Are you going in as well, Judge?
Of course.
All righty.
Okay, let's see if we're all back. Let's see, waiting on Mr. Ford. We did it. All right, Mr. and Mrs. Corman, can you unmute yourself, please?
Hello, Your Honor, we're here.
Hi, good afternoon. How are you all?
We're okay. Not great, but we're okay.
I
But
understand. Yes, do you all both want to address the court or just one of you speaking for both of you?
I think we both can, if that's okay.
Okay, and if it's not too long, but I will go ahead and swear both of you in. Can you both raise your right hands for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth, so help you under the penalty of perjury?
Yes.
Okay, put your hands down. Who would like to go first?
I will.
Okay, and you are Peter Corman, is that correct?
Peter Corman, I'm Haley's father
Okay,
and Marilyn Blitman's son-in-law.
okay,
My wife is Marilyn Blitman's daughter, and we are both caregivers for Marilyn Blitman, who is 83 years old, about to turn 84. And Marilyn has an advancing case of dementia. But what we would have liked to have been in the breakout room with Haley's attorney and the prosecutor, the ADA, and you, of course, Your Honor, because we'd like to discuss her history, which may not appear in the criminal file, but you should be aware of medical issues and psychiatric issues which impact her behavior.
okay. Let me say this to you. As far as the criminal history, I've heard as much as I need in general to make a ruling on this misdemeanor charge. These are misdemeanor charges and not felony charges. So we have assistant solicitor generals as opposed to assistant district attorneys. And I know you've been in other courtrooms and things of that nature. My only concern is that the defendant, Ms. Corman, would need to hear the presentation of her attorney. Now, if you would like to go back in the breakout room to give me some of the MH issues or MH history, only as it relates to me deciding on bond, because this is just a bond hearing and I don't have the liberty to hear, you know, a lot of history.
I just give you a brief history, so this can be considered as you, for you, as you make a ruling on how and when to release.
Okay.
Yeah.
Do you not, is this something you don't want to do in open court or you don't want to do it in front of Ms. Corman?
No, Ms. Corman can be there. I just don't think that dealing with psychiatric issues would be appropriate for for open court. I would ask to approach the bench if we were.
Right. Right. Yeah, I would have had you to do that as well. Natalia, and I've not usually had the defendant in my breakout. Is that possible? I guess it's whoever you put in there.
Yes, Your Honor.
And we do
The attorney would be okay. I mean.
Okay. Well, can you add us back to the breakout with Mr. and Ms. Corman? And then Mr. Ford can hear what it is that they have to say, because I think he needs to know as well before he makes his full presentation what the parents' intentions are. And I'd like to hear that as well.
And I would ask that once again that Ms. Kim.
Okay, so that Walker, Mitchell, Kim, Ford,
Corman, and the defendant.
Mr. Corman.
Right.
And the defendant too at South Annex.
Yes, South Annex, yeah.
South Annex. Okay. And you, Judge.
And yeah. On the
Mhm.
I'm sorry, I totally forgot we were in the breakout room. Thank you, Mr. Ford.
Next, we have position 7, Ms. Diaz. Come on, young lady.
What's the bond amount?
$5,000 cash bond, $2,500 on each. MH eval and no contact with the victim as well as the parents. And I'm sorry, Mr. Tucson, we were in the breakout and I'm thinking we were in open courts. I apologize.
What position are we on?
Position number 7,
Thank
Ms.
you.
Diaz.
That'll be my case, Your Honor.
Okay, great. All right, and do I have a new ASG? I saw Webb.
Yes, Your Honor, that's my case.
All right. Pretrial, do you have anything? Let me call this case 22 CR 000-645J. One count of battery family violence, offense date February the 8th, 2022. Do you have anything pretrial?
First arrest recommended.
Okay.
I didn't hear that, Your Honor.
You said first arrest recommended.
Okay. Thank you.
All right, Ms. Webb, you may proceed.
Yes, Your Honor. This incident took place on yesterday afternoon at 1328 Wood. That's Wood, common spelling, Creek, common spelling, Trace, Roswell, Georgia, where the defendant and her roommate, Ms. Gonzalez, had an argument over where they are working in the home, Your Honor. The two women are roommates. At some point, the defendant became extremely upset and began destroying Ms. Gonzalez's plants by taking them out of the pots and throwing the dirt and the plants around the apartment, Your Honor, and at the actual roommate. And at some point, she picked up one of those pots while the roommate was bending down to grab her dog that was underneath the table that the defendant was standing in front of, and hit the Miss Gonzalez in the back of the head with one of those plant pots, causing bleeding, Your Honor. The victim left the apartment and was able to get assistance and call the police, and EMS did arrive to the scene and issue first aid for those wounds. For those reasons, Your Honor, the state is recommending a $4,000 surety bond, a stay away from that incident location at 1328 Wood Creek Trace, and no further contact with Ms. Nydia, that's NYDIA Melendez, MELENDEZ - Gonzalez, GONZALEZ. Your Honor, and no alcohol, drugs, or weapons. Our victim advocate did get an opportunity to speak with Ms. Gonzalez today, and she does not want the defendant to return to the apartment as she is afraid based on this violent attack, Your Honor. And she has since sought out the management at the apartment complex to change the locks on that unit. Though the defendant does reside there, that lease is under the victim's name. The defendant actually moved here to Atlanta from Puerto Rico, as the two were previous college roommates. And she came over to Atlanta after the Miss Gonzalez moved here first for a couple of months. So she has been here in Atlanta since 2021. Well, the both of them actually have been here since 2021, Your Honor.
Okay. All right, Mr. Ford.
Your Honor, we're asking that you uphold the unsecured judicial release, that a signature bond be granted. My client, Ms. Diaz, is 53 years old, Your Honor. She's a college graduate that's been mentioned by the ASG. She has a very good job working for American Honda Finance. Your Honor, her children are all grown. She has a valid driver's license, Your Honor. She needs to go to work tomorrow. She has her job and she's concerned about that. She does well. She has no problem trying to find additional housing at this time, Your Honor, due to the fact that she does have employment. I do have a stable telephone number for her, a email address, Your Honor. She does have another friend that she's given me a number for, who's a co-worker of hers, Your Honor. So that's why I stated that there would probably be no issue with her trying to deal with the no further contact. Yeah, she has been here for the last 7 months, Your Honor, but she has been gainfully employed since she's been here. We feel that the recommendation of a signature bond or unsecured judicial release should be upheld. So we're asking for a signature bond no more than $1,000, Your Honor.
Right. I'm going to rule that we will issue rather a $5,000 signature bond through pretrial. I'm going to order a stay away from the 1328 Wood Creek Trace in Roswell. No further contact. Who's on? No further contact with the victim, Nadia Melendez Gonzalez. No drugs, alcohol, or weapons while on bond, except for those that are ordered by a physician. And I'm going to give a one-time police escort, or law enforcement escort to that location to retrieve any personal items. Ms. Diaz, you will need to find somewhere else to live, and you will get a one-time escort to return to get any of your personal items that you need to retrieve from that location. You will be monitored and under the pretrial rules and guidelines for reporting. And I think that's it. No further contact. I said that, and stay away. So that'll be a $5,000 signature bond through pretrial. Anything else that I need to take up?
No, Your Honor, the state rest.
Okay.
Nothing else, Your Honor. Thank you.
All right. Thank you.
Want to say something? You gotta switch. Okay, okay, switch. Come on, I gotta go. Okay, next we have position number 4, Ms. Brantley.
Okay.
Good afternoon.
Afternoon. All right, this is case number 22 CR 0000648A. There is one count of theft by taking, the offense date of October the 30th, 2021. Do you have anything pre-trial?
20 total.
How many?
Out of 20.
20. Okay.
Yeah. History out of Georgia and Jersey. I'm gonna give you the Georgia history first. 2016 shoplifting arrest. 2014 misdemeanor possession of marijuana. 2013 shoplifting conviction. Had a battery and terroristic threats and cruelty in the 3rd arrest that was dismissed from 2013. Last arrest in Jersey was 2005. Felony conviction for unlawful taking. 2004 theft by receiving conviction, and the 03 resisting officer conviction.
Okay. All right, and this is Miss Webb.
Yes, Your Honor. As Your Honor knows, this incident took place on October 30th, 2021 at the West End Mall, where the Atlanta Police Department responded to a larceny call, and they were met with a Miss Tamira Bradley. And I believe Miss Bradley is on the call, Your Honor, who reported to the officers that the defendant stole her daughter's iPhone XR. Miss Bradley informed the officers that her family came to the phone counter to sort out an issue with her cell phone, and the defendant was also at that counter selling oil fragrances. While Ms. Bradley was getting her phone checked, her daughter laid the phone down on the counter, and her husband did not notice that the daughter laid the phone down and accidentally thought the phone belonged to the defendants, and asked her if the phone belonged to her, and she said yes, it was, and she left the counter and then proceeded to leave the mall. The mother did make contact with the defendant at some point during that evening to ask her about the cell phone. I'm assuming they were calling that phone, but she was unsuccessful in getting the actual phone back. The defendant, somehow the mother was able to receive the defendant's Cash App information, which was Foxy Fresh Fragrances, and that information was given to the officer to help identify the defendant, Your Honor. For those reasons, the state is going to ask for the preset bond at $4,500 surety, a stay away from that incident location, which is the West End Mall located at 850 Oak Street, Southwest, Atlanta, Georgia, and no alcohol, drugs, or weapons, Your Honor. Again, this incident occurred over 3 months ago, Your Honor. We do believe that the defendant has a high likelihood of reoffending because she was fully aware that the phone was not hers. She did speak with the Brantley family on the day of that incident, and despite having ample time to give the phone back, she still has not done so based on what Ms. Brantley informed our office as of today, Your Honor. And plus, considering that history out of Georgia and New Jersey, including a ag assault and simple assault and receiving stolen property out of New Jersey from 2005 and those shopliftings here in Georgia since 2014, we do believe that she has a high likelihood of reoffending, Your Honor, and that's the basis for our recommendation today.
All right. Mr. Ford?
Thank you, Your Honor. Your Honor, we're asking for a signature bond on this for some type of unsecured judicial release. My client is Ms. Brantley, is 40 years old. She's a high school graduate. She has some college. She's working now for the Spring Greens on 2nd Avenue in Glenwood. She's been there for over 6 months, Your Honor. I'm looking at her charges, Your Honor, 2016, 2014. She has moved to Georgia, Your Honor, and she's here to better her life. She has her own business. She has a fragrance business as well, along with working full time. She has a stable address. She also has a stable telephone number. I have her email address. This is a situation, Your Honor, where I think you see a person who is trying to do better. She's trying to do better in her life. This is not an assaultive or any type of violent crime where the community should be concerned. She does have community support. I do have a telephone number for her fiance, where she's in the process of getting married. I believe that his signature bond at this time would be appropriate, Your Honor, due to the fact that her history, where there may be 20 cycles. I get concerns when I hear cycles because you could have been arrested and the case could have been dismissed and it's still considered a cycle, Your Honor. But I don't see where this is a person with a real violent criminal history. And so we feel that a signature bond would be appropriate somewhere around $1,500, Your Honor.
Okay. I see that I have the victim on the phone. Is it Mia's iPhone?
It's Miss Tamira Bradley, Your Honor.
Oh, I see. Sorry. Miss Bradley? Can you turn on your camera and unmute yourself if you would like to address the court or not? I see that you've unmuted yourself, but I cannot speak to you unless you can turn your camera on.
Okay.
Would you like to address the court?
Yes, I would.
Okay.
Can you hear me?
Now I can see you.
Okay.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury? Okay, you can put your right hand down. All right, and what would you like to tell me about this particular incident?
This particular incident, we were actually able to get in contact with the defendant and on several times. I mean, like literally maybe 4 or 5 hours. And we even went into the next day and actually asked her if she would just return my daughter's phone. And she was, I mean, literally nonchalant about the whole situation. We even told her if she just dropped it in a certain, place, we would pick it up and we would just let all of this go. However, she was determined that she was going to do what she wanted to do with the property, which meant to me that she was either going to sell it or try to do, God knows what. My whole thing is I actually told her this was a child's phone and she still had no remorse. So regardless of, that she's trying to do better, to me, it seems that she's still doing the same cycle that she did in New Jersey, in Atlanta. And I just feel like she needs more than just $1,500 to get out because my daughter had to suffer. So, I mean, for not necessarily suffer, but I just think the situation that happened, my daughter should not have had to experience.
How old is your daughter?
14.
14? Okay. And are you friends with Miss Brantley, and your last name is Bradley? Are you all friends, or you just know her from the mall?
No, they knew her. The people at the mall knew her. She had previously been in their store, and that's why they were upset because they were like, she has come in their store plenty of times, and nothing like this had happened before.
Right.
And that's
It's me.
Okay.
we also shared the text messages between her and the manager of the store.
Okay.
To the police.
All right. And are you in fear of Miss Brantley?
No, definitely no, I'm not.
Okay. All right. Anything else from the state or from Mr. Ford?
Nothing else from the state, Your Honor.
Nothing else other than the fact, Your Honor, that like I said, this is not a violent crime, and I feel that, and you've heard from the witness that she's not in fear of Miss Brantley, so I think that a signature bond would be appropriate, Your Honor, or should be granted. I won't say appropriate, but I said should be granted.
Okay. And right now she doesn't have a bond at present, correct? Correct from the state?
Your Honor, I had that her bond was already set at $4,500 surety, but I can double check just to make sure I'm correct.
Is that your
Yes.
understanding, Mr. Ford?
No, I don't have any information that a bond was set, Your Honor.
Yeah, I have it showing up as a $4,500 surety bond.
Your Honor, and like I said, she's here only 9 years. She needs to go to work, Your Honor. And there's nobody here, probably her fiance, but there's still the likelihood if there was a bond that was set that she might not be able to make that and get to work on time.
And again, Your Honor, you did hear from Miss Brantley, who did say that she gave Miss Brantley a fair chance at, righting this wrong. I understand that she's not necessarily violent, but we do believe she has a high likelihood of reoffending. This case occurred 3 months ago, and in that 3 months time, if she was in possession of that phone and did not attempt to actually give said phone over, but just lead the Bradleys on to believe that she would cooperate with them, since they did have those conversations, I believe she said, for 4 and 5 hours on the day of and even the day after, and she still did not make an attempt to make sure that she just gave the phone or dropped it back off at the mall at a mutual location. The state would just request that the court consider that fact.
Your Honor, in talking with my client, one of the things that we have to be concerned about is the fact that she has to make sure that the phone goes back to the appropriate person. And so at this point, Your Honor, it may take more than a few months to verify those types of things. So the ASG is continually saying it's been over 3 months. But like I said, at this point, Your Honor, I think there has to be some time given. However, I'm not saying that my client took the phone. I'm just saying that if the phone was somewhere near my client, it would have to be time to try to verify who took the phone and who it goes back to.
Right. I think what she's saying is this occurred in October, and she was just arrested, 2 days ago or 1 day ago?
Yes, Your Honor.
And I think that's the statement. If she's been out since October, she wasn't immediately arrested. And they've been in communication, seems like, so the victim states, and they've just asked for the return of the phone. What I'm going to do is I'm going to order a surety bond in the amount of $3,500 and no further contact with the victim, Miss Bradley, and her minor child or anyone in the Bradley family.
Now, please speak.
No, hold on a second while I'm giving my ruling. I'm also going to state that there be no drugs, alcohol, or weapons. She makes bond. And to stay away from the West End Mall at 850 Oak Street. Miss Brantley, if you go back to the West End Mall, you're going to be arrested. So you need to stay there and shop somewhere else. And now that I've given my ruling, is there a question that you have? Because remember, anything that you say can and will be held against you. So be very careful. If you have a question, we can address your question.
Yes, I'm asking for a signature bond because I did not do that. She did call me on the phone. I told her that I didn't have her phone. I told her that. It wasn't a nonchalant. I told her I didn't have it, and I asked them to stop harassing me about the phone.
Okay.
I asked her and she can tell you that as well. If she's gonna, I asked them to please stop harassing me about a phone that I did not take.
Mm-hmm.
So I'm begging for a signature bond because I don't have any money to get out.
Well, your case will be reheard on the
February the 22nd.
22nd. I'll do a 3,500 surety bond, but I'm not inclined at this point to do a signature bond. All right. All right. Thank you.
Thank you.
Next, we have position 13, Ms. Smith.
All right, Ms. Bradley, you're free to go. All right, thank you for your time. You said 13?
Yes, Your Honor.
Okay. All right, this is case number 22 CR 0000654G, Kyara Smith, charged with 1 count of simple battery and 1 count of theft by shoplifting, all with the offense dates on February the 8th, 2022. Do you have anything pretrial?
Second arrest, last arrest 2017 out of Michigan for fraudulent activities. I'll take it.
You okay? All right, Ms. Mitchell?
Yes, Your Honor. In this case, defendant was caught shoplifting at the Walmart on 970 Mansell Road, Roswell, Georgia, with 2 other women. The loss prevention officer and victim in this case, Mr. Timothy Molaris, spelled Molarius, stated that when he tried to stop them, the defendant slapped him in the face. The defendant was also seen on camera scanning multiple items and placing them into bags. It was clear that the defendant had multiple items in her hands and would only scan 1 item as she bagged all of the items. The defendant then placed the bags of merchandise she scanned on top of a personal cloth bag in a cart as if to cover it up. When stopped, Mr. Molaris found that the bag being covered up contained several items such as cosmetic products, infant formula, phone cases, infant clothes, and other merchandise that were not scanned or purchased. The total value of merchandise found was $312.66. Of that, $257 worth of items were not paid for.
You said how much again? I'm sorry.
$257.
Okay.
There is a current bond on this case, $1,000 surety as to the simple battery charge against the loss prevention officer. We request that that bond remain the same on that charge and a $1,000 signature bond be added to the theft charge. Additionally, we'd like to include conditions of no further contact with Mr. Timothy Molaris, a stay away from the Walmart on 970 Mansell Road, a 1-day anger awareness course, and no alcohol, drugs, and weapons. Nothing further, Your Honor.
Okay. All right, Mr. Ford?
Thank you, Your Honor. Your Honor, we're asking that both counts be made signature bonds. My client is 20 years old. She was working for Walmart in a very good position until this incident. She has a high school diploma that she is working on online, Your Honor. She does have a valid driver's license. She has a 4-year-old son that she is caring for at this time, Your Honor, that she needs to get back to. I have a stable address for her, stable telephone number, email address. She has been here for 1 year from Flint, Michigan. As you can see, she has no issues here in the state of Georgia. So we're asking that you uphold the recommendation of the pretrial services that a unsecured judicial release take place. And we ask for a signature bond on both counts of $1,000.
Okay.
And she does have She has plenty of, she has family support, Your Honor. I did get the telephone number of her mother and her sister.
Your Honor, if the state may add, our victim advocate did speak with the loss prevention officer, and he did confirm that the defendant slapped him in the face and that he wants to press charges.
All right, I'm going to order a $2,500 signature bond through pretrial, and that will be a 15, do my math for me, Miss Bridgewater.
1,500 on one and 1,000 on the other, Your Honor.
Yes, sir, thank you. Yes, 1,500 on the simple battery and 1,000 on the shoplifting, and that'll be 2,500 through pretrial. I'm going to order that you stay away from the Walmart at 970 Mansell Road in Roswell. You should not go there. I'm assuming you don't still have a job there after this incident, maybe. Also, I'm going to order a stay away from the victim, Mr. Malarius, and, or is it Mr. Norris?
Malaris.
Malaris, okay. That was the loss prevention officer.
Yes, Your Honor.
Okay, stay, no further contact with him. I'm gonna order that 1-day anger awareness course. No drugs, alcohol, or weapons while on bond. And I think that's all that I have for this matter. Anything else?
Nothing further from the state.
Okay,
Nothing else, Your Honor. Thank you.
all right, thank you.
Position number 15, Mr. Franks, please.
Your Honor, is this the add-on position 1?
That's what I was getting ready to say. I don't
Yeah,
have.
it is.
I'm just asking because I actually just made victim contact with that victim. I'm in the process of emailing her the Zoom link. She would like to be present. Is there any way we can go back to the next position so I can get her the Zoom link and she can get logged on?
Okay.
Go number 10, Mr. Jackson.
Thank you.
Number 10, Mr. Jackson.
Okay.
Your Honor, the state's going to request a breakout room on this case.
All right. Who needs to be in? Mr. Ford, Miss Kim, Miss Mitchell, Mr. Walker.
Your Honor, I do not have to be in unless Miss Kim would want me in.
Oh, okay. It's Miss Kim's case.
Yes.
Yes, Your Honor.
Okay.
Ms. Kim, do you want Ford in the room?
Nope.
Oh, how do I do
No.
that?
No,
Hold
you
on.
don't do it, Miss Kim. She's just asking. I don't think he does. Or do you?
I got a question.
Yes.
Are y'all breaking out for the add-on as well?
Yeah.
I don't know.
I don't believe so. It's not going to be a request from the state.
Okay, I was just asking.
Yeah.
I was just gonna tell the judge in the chat, you know.
Yeah, tell me what you need to tell me in the chat.
Okay. All right.
Okay.
I got them. I got them. We in another breakout session for you.
No, they're not for me. This was.
Oh, for somebody else.
Yeah.
Did they tell you bond? Oh,
So what's the bond amount?
She hasn't said it.
Judge, you're muted.
Maybe that's why. All right. Deputy in courtroom 2, is that Mr. Eric Jackson?
Here, medical.
Oh, medical. Okay, Mr. Jackson. You're Mr. Eric Jackson. This is case number 22 CR 0000649Y. And you're charged with 1 count of simple battery, family violence. Pre-trial, do you have anything?
So we're not on Richard, we're on Eric.
We're on Eric, yes.
All right, second arrest.
Okay.
The last arrest was back in November for felony theft by taking.
All right.
21 CP 204328. And that's a pretrial bond.
All right. So he's already on a pre-trial bond.
Correct.
So he is 18 years old. And so I'm assuming you're going to tell me he would not be eligible for a second one, correct?
Boom, right.
Okay. And I think his mother is on the line.
Yes, Your Honor.
Okay, there you go. Tell me your name, ma'am.
Mia Jackson.
Okay. Can you raise your right hand for me, or would you like to address the court? I'll ask you that first.
Yes, ma'am.
Okay. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth and the penalty of perjury?
Yes, ma'am.
All right. What would you like to tell me briefly?
I would like, first of all, I don't want to press charges against my son because he's the one that, it was me, that he hit. My son need help. He need to be admitted to the hospital. He has mental issues, I think almost for the past year going on now. He has episodes at the school. It been plenty of times that the paramedics had to come up to the school, but by that time they reached the school, he's not in that emotion state for them to take him to get help since he's 18 years over age. Mm-hmm. So, it's been really hard trying to getting help because he keeps saying he doesn't need help. Of course he need help. The other morning, for the past week, about 2 weeks now, he just been up all night long, pacing back and forth, talking to himself. And yesterday morning, it just took the cake. I got up, I was coming from the kitchen. He was in the bathroom just talking to himself, screaming himself, talking to himself. So I said, son, what's wrong? So, as he looking at me like, I was just a totally different person. So, I kept saying, son, what's wrong? What's wrong with you? So he just slapped me. And when he slapped me, he looked at me like, it shocked me. So I said, son, why did you hit your mama? And once I said that, he slapped me again. So I knew something, had to be wrong. So this one, I called 911. And by the time the Grady crisis came out, the paramedics, of course, the episode comes and goes. So by the time they came, they didn't want to take him. But the police officer told me, I can have him arrested and see some type of way he can get help. Cause I don't want, he need help instead of sitting in jail. He need help.
All right. What school was he attending?
He was attending Benjamin Mays High School.
Right.
He had one episode, there are a couple of episodes, but his credits was low. So for him to be able to graduate on time, they had him to do his credits at CREAM, which is open campus. That's in Decatur.
Mm-hmm.
And, he was doing very well there, but all of a sudden, I don't know what triggers it, but he had a couple of episodes at that school also. So, it's a pattern.
So he's not been diagnosed, I assume, and don't tell me what it is. Has he been diagnosed, just yes or no?
No, ma'am. No, ma'am.
All right. Okay. And at this point, are you in fear of him coming back to your home?
Yes, I'm in fear, he's going to come back, do something here, I do something to somebody on the streets that's not going to understand what's going on with him. You know what I'm saying?
Mm-hmm. Mm-hmm.
So.
Okay. And so, are there any other options for him to stay anywhere else with any family or friends?
He has two older sisters, but they stay so far out, they not on the bus line.
Mm-hmm. So does he have one more year to finish in high school?
He's supposed to come out this year, but all the episodes been going on, he's not, it's like his driven is gone, it's like he's just dead inside.
Okay. All right. So I'm ready to give a ruling. And I'm going to order, because he's already on a pretrial bond, I'm going to have to order a $3,000 surety bond. And with that surety bond, I'm going to order a MHET. So with that evaluation, the state, are you going to get me that order for the MHET?
Yes.
Oh, yes, ma'am. Oh,
okay. Yeah, the state will give me an order for that. I'm going to order for him to stay away from 3256 West. Is it Mano or Mano?
well, actually, this is my this is my mom's house. We stay with my mom, which is his grandmother.
Oh, okay. So
Yes,
what
ma'am.
address would you like him to stay away from?
This is the address that he was, he resigned at 3256. I would have to get in touch with one of his sisters, because this is his permanent address, and this is my permanent address also. I live here also with my mom.
Right. Well, what I'm doing is right now, if he were to make the $3,000 bond tomorrow, the next day, I'm protecting you all as witnesses that he cannot come back there to stay with you, because he has to stay away from that location.
Uh-huh.
And if he were to come back to that location, he could be arrested. So making sure, Mr. Jackson, you understand, if you were to make bond, that you cannot go back to the Mano Lane address where your mom is. And to stay away, or no further contact rather with you, Mia Jackson, until this case is resolved. That would be a condition of bond if he gets out, is to stay away from you, but we're ordering the MH evaluation so that we can see if we can get some help for him.
Thank you so much, Judge. Thank you so much.
All right. Oh, and no drugs, alcohol, or weapons while you're on bond, except for any medications that are ordered by a doctor. And I think that's it. Is there anything else I need to add to that bond?
The no further contact.
Oh, yes, and then no further contact with Mia Jackson. All right, so that should conclude that position.
And Your Honor, the victim on Mr. Derek Frank, who is position 1 on the add-on calendar, I believe she is present.
Okay.
I did speak with her shortly ago. She said she did not want to address the court, but she did want to be present.
Okay, all right. And tell me her name again.
Her name is Ariel McDonald. It's under A. McDonald.
Okay. All right, Deputy, can we go to Derek Frank? Is that who's in courtroom 3?
Yes, thank
Okay.
you.
Okay.
Just check your chat.
Okay.
We got it, Mr. Toussaint.
Yes.
Oh, y'all told her?
Yes.
Yes, sir.
they
Okay, I
did.
didn't know. Okay.
Thank you. All right, and this is case number 22 CR 0000659D. You're charged with 1 count of simple battery, 1 count of hindering persons making an emergency telephone call, and 1 count of theft by taking with the offense date of February the 9th, 2022. All right, and do you have anything, pre-trial?
Second arrest, 2014, driving without a valid license, dismissed.
Okay.
Recommendation, SOB jail.
And not you?
Correct. I mean, unless you order it, but I don't know. I guess due to the nature of the work, just SOB jail. That's why I said it.
Okay.
All right.
Got you. All right, Mr. Walker.
Yes, Sean, to the 1 count simple battery, the state is asking for a $3,000 surety bond. To the 2nd count of hindering persons making an emergency telephone call, the state is asking for a $1,500 surety bond. To the 3rd count of theft by taking, we are asking for another $1,500 surety bond. As to the conditions of the bond, the state is asking for a 200-yard stay away from the victim's address, which is the incident location, 250 10th Street. We are asking for no further contact with the victim whose name is Ariel McDonald. We're asking for an anger awareness course, no weapons, drugs, and alcohol. Your Honor, in this case, the victim advised to law enforcement that the defendant came to her home at approximately 7 p.m. yesterday, uninvited, unannounced. She instructed the defendant to leave. At that time, he did leave. Later on in the night or early this morning around 1:30 a.m., the defendant did return. This time, the victim was asleep in her apartment. The defendant was able to let himself in the victim's apartment without her permission. The defendant was angry and confronted the victim because she is 6 months pregnant with his child, and she had a gender reveal party without inviting him. As the verbal altercation ensued, the victim did try to get away from the defendant. I believe at one point she went to the restroom where he followed her. He then followed her into the kitchen. At that time, she did advised to law enforcement that she felt threatened. She grabbed her phone. She was attempting to call 911. At that time, the defendant, Mr. Frank, did take her phone away from her and grab her. At that time, she was in the kitchen. She was able to grab a pot and hit Mr. Frank on the legs in an effort to get loose. He would not let her go. At that time, she took the pot and started to bang on the walls of her apartment in the hopes that her neighbors would be awakened and they would call for help. That did not work either. At that time, the defendant did take the victim, Ms. McDonald, by her shoulders and throw her down onto the couch and leave the apartment with her cell phone. At that time, the victim was able to escape and drive to the police precinct located on 190 Marietta Street. I did have the opportunity to speak with the victim a few minutes ago. She expressed to the state that this is not the first time they have had an altercation. There is a history of violence, and she does not wish to have contact with the victim. In this case, the state is stressing the anger awareness course and the stay away and the no further contact, not only due to the facts of this case, but based on speaking with the victim who stated this is not the first time that something like this has occurred, Your Honor.
Okay. All right, Ms. Kim?
Yes, Your Honor. He actually is Atlanta police officer. Currently, he has been working there for 3 years, serving the country and county and city of Atlanta specifically. And he is going to the college right now, Georgia State University. His major is political science. And this is his first arrest, Your Honor, even though he may have had on other issues that has nothing to do with battery issues. This is his first offense. I think I agree with Mr. Pretrial Service. What they recommend, the signature bond from the jail is the best thing to do. And also, he does not oppose to the stay away from the house and no further contact and all the other conditions of the bond. However, we want to emphasize that this is his first offense. Thank you, Your Honor.
Okay. All right, I'm going to order a $6,000 signature bond through the jail.
Excuse me,
Yes.
I have a question.
Who's
Being
speaking?
that I'm,
Hold on a second. Who's speaking?
this is Ariel McDonald.
Okay, do you want to address the court? Because first you told me you didn't, so I wanted to make sure. Do you want
Yes,
to?
ma'am.
Okay, so if you want to speak and address the court, I need to see your face and I need to swear you in.
Okay, the phone that I'm on right now, the speaker is not loud enough, so I can't hear.
Okay, I can see the top part of your head, but I'm gonna need to see your face. Can you turn around for me? Okay. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth, so help you, under the penalty
Yes,
of
ma'am.
perjury? Okay, go ahead and tell me what you'd like to tell me about this case.
Being that I'm doing 3 months, and I heard you said that it's no contact. So after I give birth, he cannot contact me about his child, because that's the most important thing for him to be in his child life, is what I want, regardless of the situation now, as long as it's a safe environment.
Well, that's what I'm trying to assure with the bond conditions that I'm going to order to ensure that you and your child will be safe. And usually what I do in those instances is that if there's to be contact with a minor child, and in your case would be a newborn child, that would be done through third parties, and because I'm going to order that he would not have any contact with you. And so once your child is born, if you want him to see your child, you must arrange that through other third parties so that he doesn't violate his bond by coming within 200 yards of you.
Yes, ma'am.
So is that going to be okay?
That's perfect.
Okay. All right. So let me go ahead and give my ruling. And that will be, as I stated, $6,000 signature bond through the jail. There will be no further contact with the victim, Ariel McDonald, while on bond. I'm going to order that once the child is born, that any visitation that occurs with the child, with the minor child, will be facilitated through third parties and other persons. He is to stay 200 yards away from the victim, no further contact with the victim. I think it also says on there, no further contact through emails or other third parties. But he can, through third parties, if you want to send pictures and things of that nature, you can send them to your third party person so they can send them to him. But I want to make sure that you are not conversating with him through emails and other forms or text messages. All of those are prohibited while he's on bond. And
yes, ma'am.
I'm going to order a stay away from your location. I think it's 250 10th Street.
Yes, ma'am.
Okay, he needs to stay away. If he comes to that location, he will be arrested, and I know he's familiar with that. So right now we want him to stay away while he's on bond. All right, anything else I need to take up, Ms. Kim or Mr. Walker?
Yes, Your Honor, briefly, the state would strongly urge the court to reconsider and to include an anger awareness course. After speaking with the victim, she was 6 months pregnant when this occurred this morning. Secondly, she advised to the state that this is not the first time that something like this has happened. So I feel like based on those facts of the victim being almost due in 90 days, as she stated, there's a history of violence. I think that it would be appropriate and beneficial for the defendant. Obviously, they do have a child together, whether he has contact with her or not. They will have to be co-parenting for the next 18 years or so. So I think at this time, all parties involved will be benefited from an anger awareness course, Your Honor. So I would just ask the court to reconsider and to include that as a bond condition. All
right, I will reconsider, and I will include the anger awareness course as a condition of the bond. And I'm assuming will the defendant get that information?
So the anger awareness is through pretrial. So he just gonna order pretrial, I guess.
Yeah, that, because Mr. Walker, he would have to find that from some other location unless.
Well, whether it's ordered through pretrial or he finds it through another service provider, I think that doesn't change the facts of the circumstances. As I previously stated, there is a history. The victim is 6 months pregnant. The state is concerned for her safety along as the child's. The judge can order it through pretrial per judge, but I don't think it would be cumbersome to the defendant to have a pretrial signature bond on an offense such as this. Again, the state was requesting a surety bond, so I don't think that's inappropriate, if you will.
Okay. Well, if you will take him, I'd like to order it through pretrial so that he can get the anger awareness course.
Can you break down that bond, Judge?
I'm sorry?
Can you break down the bond? You
Oh,
said
yes.
$6,000, but break it down, please.
Yes, 3,000 on the simple battery, 1,500 on the hindering person, and 1,500 on the theft by taking.
And just to be certain, there was a condition of no weapons, drugs, or alcohol, Your Honor?
Right, no weapons, drugs, or alcohol.
Thank you, Your Honor.
Your Honor.
Yes.
Unless it is not required by his job. Can we say that?
We can say that. I'm assuming he may be suspended from his job, so unless he's using the weapon for work, but I'm very leery.
Yeah,
leery
the
of
state
that.
would object to that. I understand that he is a law enforcement officer, but I, as a representative of the Solicitor General's office, do not intend on treating this case different from any other domestic violence case. We have had other individuals who may not work for APD, but they are law enforcement officers, or they are security guards who have to carry weapons, and the condition of no weapons, drugs, or alcohol were implemented as a condition of their bond. We have people who come through here arrested on hit and run, who their job, they might drive for Amazon, they might have a CDL license, but certain conditions are still imposed. So I would just ask that the court does not give this individual any special treatment and allow him to carry a firearm. Whether he has a no contact order or not, we all know in domestic violence cases, when one party has a weapon, the likelihood of a fatality exponentially increases. So I would ask that the exception of his job is not included and it's a straight no weapons, drugs, or alcohol at any point in time while on bond, Your Honor. Again,
Your Honor,
considering that there is a history of violence.
Your Honor, there is no evidence other than statements from the complaining witness at this point. He should be presumed to be innocent, and he claims that all the allegations are false. He denies the allegations.
I understand that. So do most defendants deny all the allegations. And that's my point. I don't believe that this case should be treated any differently than any other defendant. If there's other defendants with similar or same accusations who had a condition of no weapons or drugs or alcohol, whether they were a security guard or whatever, I have prosecuted cases where the defendant was a member of the Army or the Marines. Obviously, that's a part of their job, but they were treated the same as any other case, and the condition of no weapons, drugs, or alcohol were implemented as a condition of their sentence. We, as a standard practice, implement that as a condition of these type of bonds for a reason. So I would ask that this defendant is not treated any differently, and that the conditions of no weapons, drugs, or alcohol is implemented with no exceptions, just as any other case, Your Honor. I think it would be inappropriate.
I agree.
Excuse me.
One last thing, Ms. Kim.
No,
Can I
Your
say
Honor.
something?
I didn't say that.
Oh, that was not you. I'm sorry, Miss McDonald. Yes,
Yes, ma'am.
briefly. I'm sorry.
Is
Yes.
it any other alternative that we can use? Because at the end of the day, that is my child's father, and he has 2 other kids, and though he has to take care of those kids. So if he has no firearm, that means he can no longer work in a police officer capacity. So is it a
Well,
way
he
that
can-
he can do desk duty where
Well,
he's sitting down and he's not?
I
on the
can't tell
street?
them. Yeah, I can't tell them what to do, but obviously he could do desk duty, and he doesn't need a weapon for the desk duty. So, but that's not my call. That will be up to his employer to determine that.
Okay.
Who's
Because
speaking?
I was.
Who's speaking? Hold on.
Sorry.
Who was that speaking? Who was that just spoke?
My peer representative, ma'am.
I'm sorry?
My peer representative.
Your peer representative?
Yes, ma'am.
And who is that person? Because I have to know who's speaking. These hearings are being recorded, but I have someone speaking. I don't know who it is. And that's what I'm wondering.
Her name is gonna be Sergeant Sturdivant.
And she's a peer representative from the defendant's employer?
Yes, ma'am.
Okay, that's interesting. And I
Very
can't have
much so.
I can't have someone speaking who has
Is
not.
a co-worker of the defendant.
That's very conflicting. And I'm going to say that since that person did not announce themselves as being on this Zoom call, I have not sworn them in. I cannot see that person, and I, would ask that they not participate in this hearing.
No problem.
Okay. All right. So anyway, what I'm going to order again, Mr. Frank, I want to make sure that you're clear about this bond, and Ms. Bridgewater, make it clear that due to his employment, he is authorized to carry a weapon, but he is not to carry a weapon of any sort for work or pleasure during this bond period. And so he'll have to figure that out with his employer for desk duty or seek other employment while he's on bond. Because I think the sheer fact of the arrest will probably suspend him anyway. So, he cannot carry a weapon even for work, because I am concerned about the alleged actions. And it could have been much more serious with a pregnant victim. And so I want to make sure my victim is safe at all accounts. And so, Mr. Frank, you're not to go to her location, or else you can be immediately arrested.
And
you
Your
are not
Honor,
to
sorry to
carry
interrupt.
weapons.
But I just want to make clear, there is no work exception, correct?
No work exception.
Thank
So
you.
make
I have
it,
none of these, no weapons, drugs, or alcohol at any time.
Thank you.
well, and just add to that too, Ms. Bridgewater, no exceptions for his employment.
Okay.
I think that's a good language to add. Thank you, Mr. Walker. No exceptions for employment to carry weapons. Because we are trying to ensure your safety, Ms. McDonald, and making sure that this does not happen again, or that you're not in danger.
Yes, ma'am, I understand.
Okay, I appreciate that. All right, that should conclude this matter. Anything else, Ms. Kim or Mr. Walker?
No, Your
Nothing to say,
Honor.
Your Honor.
Thank you.
Thank you. Thank you for your time, Ms. McDonald. Good luck to you.
Good afternoon, Your Honor. This is courtroom 2, Officer Norris. We got position number 6, Miss Cameron, position number 6.
Thank you. All right, this is case number 22 CR 0000650J. And I think it's Ty or Tay Kamen. Not sure if I'm pronouncing the first name correct, so I apologize if I'm not. You're charged with 1 count of possession and use of drug-related objects, a second count of public drunkenness, drunk, and 3rd count of criminal trespass with the offense date of February the 8th, 2022. You have anything pre-trial?
7 total. Last arrest was back in December. Theft of services. That's a $3,000 pretrial bond. 2018 shoplifting conviction. 2018 failure to appear for shoplifting. Another 2018 shoplifting, failure to appear. 2018 shoplifting conviction. 2014 shoplifting conviction.
All right. Ms. Webb, you may go.
Yes, Your Honor. This incident occurred on yesterday evening around 7:40 p.m. at the Georgia State campus on Gilmer Street. Officers responded to a trespass and disturbance call, and upon responding, they were met with the defendant. The defendant was issued a previous notice to stay away from the Georgia State campus, and she returned. The defendant was intoxicated and yelling at passerbys on Gilmer Street that she was going to go to CNN and kill her husband in his BITCH tomorrow. The defendant's person did reek of alcohol, Your Honor, and her speech was slurred. And considering her conduct, it did lead the Georgia State Police to reasonably believe that she was intoxicated at the time. The officers also located a crack pipe on the defendant's person, Your Honor. For those reasons, the state is requesting a $1,000 surety bond for the drug-related objects, $1,000 surety for the public drunkenness, and a $1,500 surety for the trespass, a stay away from the Georgia State campus, and no alcohol, drugs, or weapons while out on bond. We are making this request, Your Honor, because we do believe that the defendant has a risk of reoffending, as she was previously issued a stay away from the Georgia State campus and still returned. And that stay away was active in place according to the warrants applied for by the Georgia State Police, Your Honor. Additionally, we believe that the defendant is also a flight risk, considering that she does have previous FTAs from DeKalb County, 2 of which were in 2018 for 2 separate cases, Your Honor. For those, these are the reasons for the state's recommendation today.
All right. Mr. Ford?
Thank you, Your Honor. Your Honor, we're asking for some type of unsecured judicial release, signature bond. This is not a violent crime, Your Honor. The problem you have with Georgia State's campus that a person has to understand the different areas in the city and downtown where Georgia State has campuses. And so that I think my client understood that she had to stay away, but didn't understand exactly where. But she doesn't feel that she's guilty of any criminal trespass at this time. Your Honor, she's a high school grad, 2 years of college. She just started a job at Publix on Lenox. She has 3 children, 2 boys and a girl. One of the boys is 2, the other one is 6. The girl is 14 years old. She's a primary caregiver for those children. I do have a secure or a stable address for her, along with a telephone number. She does have community support. I have a telephone number for her mother. As well. She's not a risk of flight. She's been in Georgia her entire life. She's not going anywhere, Your Honor. She's not a risk of reoffending at this time. If you take a look at her last theft by taking was 2018. She's trying to understand and do better in her life. Your Honor, I think this is a great opportunity for a person to go out, take care of her children, go to work, and be a productive member of society. So we're asking that there be a $1,000 signature bond on each charge.
Okay. I'm going to order a $3,500 surety bond. I'm going to order again that there be a $1,000 bond on the first charge, possession of drug-related objects, $1,000 on the public drunk, $1,500 on the criminal trespass, and that should equal $3,500. I'm going to order a stay away from Georgia State's campus as best we can, specifically Gilmer Street, but she's not to go on campus anywhere that is Georgia State University property, since she's already been given a trespassing order. No drugs, alcohol, or weapons while on bond. And is there anything else I need to add to that bond? Any other conditions?
Nothing from the state, Your Honor. We just wanted to ensure that there was a stay away issued and no alcohol, drugs, or weapons while out. Those are our only 2 additional conditions, Your Honor.
Okay, I think I have those right, Ms. Bridgewater.
Your Honor, and you said 1,000, these are surety bonds?
Yes.
Okay. Thank you.
Mm-hmm.
That's everything.
Okay, thank you. All right, that will conclude this matter.
Your Honor, next we have position number 5, Ms. Buchanan.
All right, this is case number 22 CR 000-643J. And is it, I don't know if that's Taylor
Yes, ma'am.
Okay. Taylor Buchanan, you're charged with 1 count of battery family violence, offense date of February the 8th, 2022. You have anything pre-trial?
Your Honor, actually, this case was assigned to conflict attorney, and yet conflict attorney was not, I guess, contacted today. So we don't have a
conflict.
Hello. I'm gonna go pro se.
I'm sorry?
I'm gonna go pro se.
Is this the defendant speaking?
Yes, ma'am.
And what did you say again?
I'm gonna go pro se.
Someone, they'll be
He
coming.
said pro se, Judge.
Oh, you want to proceed pro se and represent yourself?
Yes, ma'am.
Have you been advised about that and knowing your rights to represent yourself?
No.
That would be very important. If you represent yourself, you have to know the laws, and you probably can't testify because you're going to be speaking against your interests, and those things can and will be held against you because the state is listening. I think you need to wait till your conflict defender. That would be better because these are serious charges. Can we get one here tomorrow, Ms. Kim? Guess you
I hope so.
Answer to that.
Yes, I do not have an answer to that, but I will contact the right person to contact.
It's okay. I would like to go pro se today.
Do you all usually advise them any further, Ms. Kim, when they want to be pro se?
We usually say remain silent because anything that she says will be used against her or can be used against her.
Right. Do you still, with those concerns, Ms. Buchanan, do you still want to represent yourself?
Yes, ma'am.
Is there anything that you all have them to sign, Ms. Kim?
No, Your Honor.
All right, understanding the seriousness of the charge, Ms. Buchanan, you still willing to proceed with this bond hearing and representing yourself?
Yes, ma'am.
And again, you have a constitutional right to remain silent. Anything you say can and will be used against you. You have a constitutional right to representation. And we will try our best to get that representation for you tomorrow if you want to wait until tomorrow to have this hearing so that you can get some adequate representation. You willing to wait till tomorrow, or you want to still go forward today?
I'm gonna go forward today.
Okay. All right. Go ahead, Ms. Webb.
Yeah, you want the history?
I'm sorry, pretrial.
Fifth arrest, 2014 marijuana conviction out of Texas, 2012 marijuana conviction, Texas. Last arrest was back in August for DUI out of Cobb. She don't have any violence. She was recommended.
Okay.
Yes, Your Honor. This incident took place on yesterday evening around 9:30 p.m. at 8356 Roswell Road, Sandy-R, excuse me, Your Honor, 8356-R Roswell Road, Sandy Springs, Georgia, where the Sandy Springs, the police department responded to a dispute call and was met by the defendant. The officer noticed that she had a scratch on her forehead, and when he asked her what happened, she informed him that she fell. The officer was then met by Mr. Jarrell Duncan. That's Jarrell, J-E-R-E-L, Duncan, D-U-N-C-A-N, who informed the officer that the defendant attacked him, and he showed the officer a video of his bloody nose and the scratches on his face. The parties do reside in the same home, Your Honor, but after witnessing that video, the officer did place the defendant under arrest. For those reasons, the state is recommending a $3,000 surety bond, no further contact with Mr. Duncan, a stay away from the incident location at 8356-R Roswell Road, no no alcohol, drugs, or weapons, and a one-day anger awareness. Your Honor, we are concerned about witness intimidation in this case. The parties do reside in the same home together, and it is unclear as to what initiated that argument. But if Mr. Duncan does something that will cause the defendant to become agitated in this manner again, the state is concerned that she will reoffend with violence towards Mr. Duncan, and we will be right back here.
All right. Ms. Buchanan, treading real light here and also very cautiously. I don't think there's anything else that you may want to tell me. I'll ask you a few questions since you are representing yourself. How old are you?
I'm 29 years old.
Are you married to the victim, Mr. Duncan?
No, ma'am.
Okay. And you all reside together at the 8356R location on Roswell Road?
Yes, ma'am.
Is your name on the lease?
Yes, ma'am.
Are both names on the lease?
Yes, ma'am.
How long have you resided there?
I think it was August.
Since
No,
August?
sorry, June.
You've resided there since June?
We've lived there a while. We renewed again in June, so it's been almost about 2 years.
Do you work?
Yes, ma'am.
Where do you work?
Athena Health.
I'm sorry?
Athena Health.
Athena Health. How long do you work there?
I started working there in November of last year.
All right, here's what I'm going to do. I'm going to order a signature bond through pretrial. And that amount will be $3,500. And I'm going to order the one-day anger awareness course. I'm going to order that you stay away from the 8356R Roswell Road, Sandy Springs. So you need to find somewhere else to live in the meantime while you're on bond. You're not to return to that location. I'm going to order a no further contact with Jarrell Duncan. I'm going to allow you to have a one-time law enforcement escort back to that property to retrieve your personal items. No drugs, alcohol, or weapons while you're on bond. And I think that's all I need to do. Anything else from the state?
No, Your Honor, nothing else from the state.
All right. That will conclude my ruling.
Next, we have position 2, Austin.
Huh? This is Tashana Austin.
Yes, ma'am.
Case number 22 CR 0000644Y. You're charged of 1 count of battery family violence, 1 count of simple assault family violence, both with the offense date of February 8th, 2022. You have anything pre-trial?
I got first arrest. State, do you have first arrest as well?
Yes, I have this as a first offense as well.
Okay. She's recommended.
Okay. All right, Ms. Webb.
Yes, Your Honor. This incident took place on yesterday at 419 Chamberlain, the CHAMBERLAIN Street, Southeast, apartment E6, where the Atlanta Police Department responded to a damage to property call. Upon arriving to the scene, the officer heard screaming and was met by the victim, Mr. Alante Vaughn, and that's Alante spelled ALLUNTAE, Vaughn, VAUGHN, who was yelling, "You sprayed me in the eye." The officer came in contact with traces of pepper spray in the air and could smell the odor. And the defendant informed the officer that Mr. Vaughn and she share a child together. And the argument started when Mr. Vaughn busted through the door and threw her $700 laptop on the ground and broke it. Mr. Vaughn at some point exited the home to retrieve his wallet that the defendant threw over their balcony. And while he was getting the wallet, the defendant then maced him from a distance, Your Honor. Mr. Vaughn was charged with trespass to property. And of course, the officer did charge Miss Austin with battery and simple assault, Your Honor. For those reasons, the state is making a recommendation for a $2,500 surety for each count, no further contact with Mr. Vaughn, a stay away from that incident location at 419 Chamberlain Street, apartment E6, and no alcohol, drugs, or weapons, and a one-day anger awareness, Your Honor. Again, the state does understand that this is her first offense, but considering at the time when she did mace Mr. Vaughn, she was not in immediate danger for her life. He was actually downstairs on the lower level, retrieving that wallet that she threw over. And despite there being distance and nothing to place her in reasonable apprehension, Your Honor, she still maced him. So for those reasons, we are concerned with a likelihood to reoffend and with witness intimidation, since they do share a child and home together, Your Honor. And if they cannot resolve their issues amicably, the state is concerned that they will result to violence again.
Okay, Mr. Ford?
Thank you, Your Honor. As you've heard, the ASG has stated that the complaining witness in this case broke through the door and knocked her $700 laptop to the ground. I don't believe in any case like this that when there's possible self-defense that you have to wait for the person to pull the trigger before you react. And so if this person felt that they were in danger, I think a macing was appropriate. But however, we're not here for that, Your Honor. We're here to say that she's being recommended for a unsecured judicial release at this time. She is a high school grad and is due to graduate from her school with an associate's degree, in around September of this year. This person is a very productive member of society. She has a full-time job at the Lenox Park Medical Center, where she's an insurance verifier. She works in insurance verification. She has a stable address that's been stated. She also has a stable telephone number, email address. She's been a lifetime resident here in the state of Georgia. She's not a risk of flight. She's not at risk of reoffending, because this is her first offense, Your Honor. And I believe this is not even an offense due to the fact of the facts that have already been mentioned by the ASG. She does have a 3-year-old child that she is a provider for. She has tremendous community support. She has her mother, who I have a telephone number for. Your Honor, we believe that a unsecured judicial release or some type of signature bond around $1,000 would be appropriate at this time.
Okay. I'm going to order a $5,000 signature bond through pretrial, $2,500 on each charge. I'm going to order a stay away from 2549 Chamberlain Street, E6?
419 Chamberlain Street, apartment E6, Your Honor.
41?
Yes, Your Honor. 419 Chamberlain Street. Chamberlain spelled CHMBERLAIN Street, Southeast, apartment E6, Atlanta, Georgia.
All right, I'm going to order a stay away from that location. I'm going to order no further contact with the victim, Alante Vaughn. If there's going to be any visitation with the child or the children that they have together, that will be facilitated by third-party contact. Ms. Austin, you'll need to find another place to stay while you're on bond. I'm going to order the one-day anger awareness course. Going to order no drugs, alcohol, or weapons while on bond. She will get a one-time law enforcement escort back to that location to retrieve any personal belongings.
Your Honor, just to speak to the stay away, being that the complaining witness in this case was arrested as well. And I think there could be a stay away in that. Could it be if my client's name is on the lease, I would think that the stay away would be the other way, that the complaining witness not be allowed to come to, because he's the one that broke through the door, who penetrated Miss Austin's home. I believe he was arrested as well. So I believe because her name is on the lease, that the stay away should not be her.
I think she said, is it just whose name's on the lease, both of their names or just hers?
You can ask her, she's raising her hand right now. Is it just your name? Am I correct?
Yes, Your Honor, my name is on the lease. Mine's alone.
Yours alone?
Yes, ma'am, mine's alone.
Okay. Well, what I'll do, and I apologize, Miss Bridgewater. I know when I change it messes it up a little bit, but we can fix it. So we'll order that you will stay away from that location as long as the victim is there. And if the victim is not there, then you can reside in the apartment due to the fact that just your name is on the lease.
Your Honor, wouldn't a no further contact, I mean, if there's no further contact, I don't believe, because the lease is in my client's name, that no further contact would suffice. But I think staying away from this address with the fact that she is the caregiver for the 3-year-old child, I believe would put her in a very awkward position at this time. She has a full-time employment. She has a child to take care of. I would just think there should be a no further contact. And at that point, I would think that that's what's going to happen in the other case, that there will be no further contact. So the complaining witness would know to stay away from Tashana Austin. And if we could, he was charged, I think the ASG just did announce what the complaining witness was charged with. What was he charged with?
What is the complaining witness on this case? I mean, on this calendar, since they were both arrested? Is the companion case on the calendar today?
I may be incorrect, Your Honor, but I believe Mr. Duncan was released on a copy of charges. Because I'm not seeing where he was arrested as well. I could be incorrect.
I couldn't find him arrested either.
I thought the ASG mentioned in her opening that he was arrested.
No, I did not for this case, Mr. Ford.
All right. Then my error. I thought I heard that. I thought I wrote it in my notes here, but
I did not, Mr. Ford. I did not write that. I mean, I started when you told me that because I didn't know if I had a dual arrest here, a companion case.
Because there was the fact that he broke through the door and knocked the laptop. I thought it was mentioned that he was arrested on those charges.
Well, we could ask the defendant. She would know. Can you ask her? She's raising her hand.
Yes, I will answer the question. No, he was not arrested, unfortunately. I was the only one that was taken into custody.
All right. Thank you for the clarification. Thank you.
Yeah, no problem.
I'm still concerned, Your Honor, about the fact that she, who's a person's name on the lease, and the person breaks into her home, knocks the laptop. We have that as part of the evidence today because it was mentioned by the ASG that she will have to vacate her home where she has a child.
Right.
So, Your Honor, I hate to interrupt. I've been trying to stay out of it for as long as I can.
Well, I know you're there. Give me what you feel.
So a couple of things. Your naming on a lease is not the only way to establish residency. If I stay at your location or in your home for more than 30 days, I am a tenant just like you are, whether my name is on the lease or not. Obviously, the other party was not arrested. This defendant was arrested for a reason. And if this victim is residing at the location, whether his name is on the lease or not, does not entitle the defendant the ability to return to the incident location. So because the other party was not arrested per the warrant, it reads as though the victim is in fact living at that location, we would ask the court to stick by its original ruling. Thank you.
Okay, thank you.
I still stand that if her name's the only one on the lease, Your Honor, at this point, I understand landlord-tenant law is a certain, caveats to people staying there for a period of time. But if he's just a visitor coming in every now and then because they have a child in common, I still believe that she should have access to her home that she's paying rent on, that her name is on the lease, that she is providing for the child. I think it puts her in a very awkward position, not being able to come back to her own residence, even though it is the incident location.
Okay. So what I'm going to order, and let's see, Ms. Bridgewater, I think initially I had set a stay away from that location, but I will clarify it and say she may return to that location as long as the victim is not there. If the victim is there, then she will need to take the proper avenues or channels with the dispossessory or something to have the victim put off those premises. But again, if she goes there and the victim is still residing there, I'm going to ask that she find other locations because I'm ordering no further contact with the victim. So having no contact means not living together. So I will stick by a little bit what I said initially. She can go there and reside there as long as the victim is not. And if the victim is determined to stay there for whatever reasons, then she must take avenues to protect her and the child not be there. If they're going to have visitation with the child, that should be facilitated by a third party, so that they do not have any contact and are not living together at that location. Is that clear, Ms. Bridgewater?
It is. However, will you give me those bond amounts again?
Yes, ma'am. Battery 2,500 and the simple assault 2,500 for a total of a $5,000 signature bond through pretrial.
Thank you.
And then you've got the 1-day anger awareness and the no drugs, alcohol, and weapons.
I do, and a one-time escort.
One-time escort, if
ma'am.
needed, if she goes there and he's still there. Okay.
All right, next, Judge, we have position 14, Sylvester.
Okay. All right, case number 22 CR 000-655F. And this is Justin Sylvester. You're charged with 1 count of hindering person making emergency telephone call, 1 count of criminal trespass, 1 count of simple battery. All with the offense date of 12/21/2021. You have anything pre-trial?
Third arrest, 2019 forgery, 3rd degree, giving false name, on probation. Out of Fayette County for that. Before that was a burglary from 2011. It was a minute to trespass conviction. That's it.
Okay. All right, Ms. Mitchell.
Yes, Your Honor. In this case, the defendant battered Miss LaDaja, spelled LaDajja, Truesdell, spelled Truesdell, who is the other person living in the same household, by grabbing her arms and neck. The incident started when the defendant came home drunk, and Miss Truesdell took her and her 5-year-old son over to her neighbor's apartment due to defendant's behavior at the time. The defendant then followed them over to the neighbor's apartment. When Miss Truesdell tried to leave, the defendant grabbed her by her arms and neck. When she was able to get free, both her and her son went back to her apartment where the second incident occurred. The defendant was being overly aggressive with her son, telling the 5-year-old he couldn't watch TV and to go to bed. When Ms. Truesdell intervened, the defendant told her, quote, to take her son's dick out of her mouth, as stated in the warrant. And that was stated in the presence of the child. The defendant was asked to leave the residence He left shortly, but then returned kicking in the door. Ms. Truesdale tried to call 911 when the defendant slapped her phone away. Ms. Truesdale's son was so terrified that he tried to defend her with a toy sword. Your Honor, in this case, the state's bond recommendation is going to be a $2,000 surety bond as to count 1, a $2,000 surety bond as to count 2, and a $2,000 surety bond as to count 3, totaling a $6,000 surety bond with no further contact with LaDaja Truesdale, a stay away from her residence. My apologies, I don't have that at this time, but I'll get that for you shortly. A 1-day anger awareness course and no alcohol, drugs, and weapons. Your Honor, the state's concerns here that this being the violent nature of the allegations in this case, and it all taking place for another 5-year-old, and the fact that the defendant is violating his first offender conditions on his forgery conviction and from 2019, all add to our concerns and serve as the basis for our recommendation at this time.
Okay. Yes, Your Honor. Mr. Justin is actually 27 years old. He has been here in Georgia for 21 years. He was born in Chicago, but he came here when he was 6 years old. And he does not oppose to stay away from the residency. He is willing to stay with his parents for now. And he has a job that he started about 2 weeks ago, and it's very important for him to keep the job so that way he can pay for his 5-year-old son. And he works as a forklift driver at DHL. He has a certification to do that work, and he has been working in the logistics industry for a long, long time. And he graduated from high school in 2013. And right now, he is also going to attending Atlanta Tech Business School. He is a sophomore there, and he has been productive citizen here in Georgia. So we would like to request for surety bond so that way he can get back to work. Thank you, Your Honor.
Hi, can I say
A
something?
signature bond. I'm sorry, I meant to say signature bond for him. Thank you.
And Your Honor, I see that Ms. Truesdale is on the line, but before you sound for her, I would like to clarify that the 5-year-old involved in this case, to our understanding, that is not the defendant's child. Also, I have the address for you for the record. We're gonna request a stay away from the residence at 5100 Welcome All Road Southwest in South Fulton, Georgia. Nothing further, Your Honor.
All right. Ms. Truesdale, can you turn your camera on? You have to turn on your camera. I have to be able to see you. There you go. All right.
Hello, how are you?
I'm good. Would you like to address the court?
Yes, ma'am. Only thing I would like to say is that
Hold on. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, now you can go ahead. Tell me what you'd like to tell me about this incident.
I would just like to say that Mr. Sylvester, he's a really good person. It's just when he drinks, he turns into a different person. So if anything, if we could like get him into some like AA meetings or anger management or some, drinking or something like that, because he really just needs help, if anything. Personally, that's how I feel. Because when he doesn't drink, he's a good person. He's really good to me and my son. He really takes care of us. He really loves us. But when he drinks, he just turns into a different person. I don't fear him unless he's drinking. But since that incident, he hasn't been drinking. He's been sober. He's been looking into getting some therapy, but that's just been a little bit of a financial situation. But when he's not drinking, like I said, he's a good person. He takes care of me and my son. He really helps us. He provides for me when he can. But when he's drinking, he just turns into a different person. So I just feel like he needs help,
rather than sitting in the jail, because I do know that drinking is a real addiction. It's a real problem. So if we can get him some help in regards to that, I feel like he would be doing good because, like I said, like they stated before, he started a new job. He's going to school. He's trying to better himself. So if we can just get him to stop drinking, I think we'll be on a right path.
Your Honor, based on that testimony, the state would like to request that ADAT be added as well.
And I would like to emphasize the fact that the past history is not related to the current charges, Your Honor.
Say that again, Ms. Kim.
This is his first battery offense. The previous one is forgery, which is totally different nature, Your Honor.
All right. I'm going to order the $6,000 surety bond, $2,000 on each charge. And I'm going to order a stay away from the 5100 Welcome Mall Road. I'm going to order no further contact with the victim. And let me make sure, I guess here I go again, Ms. Kim, with this location. Who resides there at the Welcome Mall Road?
I believe currently Mr. Justin and Ms. Truesdale live together.
Okay. And so, again, I'm assuming Mr. Sylvester can find another place to live because I was going to order him to stay away from that location.
Yes.
I don't know if I have any objections on your part from that.
Can I say something?
Quickly.
Well, where he works, it's close by here and it's convenient to here. Like I said, we've been okay. We've been fine. I haven't had any violent incidents. We haven't had any arguments. So I don't know if you can go with the stay away. I don't need him to stay away because like I said, even when we don't talk, he doesn't come back here. Like if something happens, if we argue or something like that. So I don't think we need to stay away and no contact.
So this incident happened in December, and I don't know if he was drinking around the holidays or if that's what you're alleging. And then now he's arrested. He was just arrested February the 8th from the December incident. And are you telling me there have been no incidents since December 21st?
No, ma'am, no incidents.
Does the state have any objections to removing the stay away for the defendant?
Yes, Your Honor, at this time, we are going to object to that. We are concerned for the defendant, for the victim, Ms. Truesdale, and her son at this time. It sounds like, based on her testimony, that if he drinks, that there's a high possibility that this would occur again. As much as we hear her on her testimony, if he gets out tomorrow and drinks and then another incident happen, that's going to be on us, and we don't want anything to happen to them. In addition to that, he is violating his first offender act, his probation on the forgery charge by catching these charges. So we're going to maintain the no for the contact and the stay away for the best interest in all parties involved, Your Honor.
Okay. All right. I'm going to, again, go ahead and order the stay away. Mr. Sylvester will have a one-time police escort to come and retrieve his personal belongings. I'm going to order no further contact with the victim. No drugs, alcohol, or weapons while on bond. And I think that is it. Anything else I need to take up, Ms. Kim or Ms. Mitchell?
No, Your
Um,
Honor.
May we add or request a SDET, ADET, based on Ms. Truesdale's testimony? We're concerned that he may have an issue with drinking.
I'll go ahead and order that he get an ADET and follow any recommendations that report may show.
Thank you, Your Honor.
All right, that will conclude this matter.
Thank you, Your Honor.
Thank you.
Next, we have position 9, Edwards.
Number 8 bonded out, correct?
Deputy, did number 8 bond out, Mr. Dobbs?
Yes, he did.
Number 8
Anybody
and number
else?
12. Number 12.
That is correct. Who's number 12?
Uh,
Yeah, Mobley. Bonded out.
Thank
Yeah.
you. Find it out.
Okay. Thank you, pre-trial.
Anything that help out.
Appreciate it. All right. This is it Cabarcier Edwards?
Yes, Cabarcier.
All right. Case number 22-000647G. You're charged with 1 count of simple battery family violence. The offense date is 11/21/2021. Pre-trial.
First arrest, recommend.
Okay. All right, Ms. Mitchell.
Yes, Your Honor. In this case, as stated in the police report, the defendant battered Miss Zatanya, spelled Zatonya, Gates, the mother of their son that they share together, by pushing her multiple times. It started when the defendant came to the location to drop off their child. The defendant began to argue with Miss Gates and cursed and yelled at her. Every time Miss Gates reached to get her son out of the car, the defendant was violently bumping her out of the way, preventing Miss Gates from getting to her son. Miss Gates was pregnant at the time of the incident. The state's bond recommendation is going to be a $2,000 surety bond, no further contact with Zatanya Gates, third-party contact with their child, to stay away from address 540 Humphrey Street, Atlanta, Georgia, 1-day anger awareness course, and no alcohol, drugs, and weapons. The state's concerns here is the fact that defendant caused this incident by violently pushing Miss Gates out of the way to keep her from getting their son from his car, meaning this took place right in front of the child. And the fact that Miss Gates was pregnant at the time adds to our concern and will be the basis of our recommendation today, Your Honor.
Okay.
Your Honor.
Kim?
Yes, Your Honor. Mr. Edwards is 24 years old, and he is actually very creative musician. He does raps as a musician, and also he has his own brands. It's called Louis to Approved. He makes clothings and he designs different kinds of clothes with his own sewing machines. And he has been responsible for his 4 years old son who had a birthday not that long ago, December 18. He has been a good father, so I don't think that there's a need for third party stay away. And also, we would like to request for a signature bond since this is his first offense. Thank you, Your Honor.
And just to clarify for Ms. Kim, we're just requesting a third-party contact with their child so that the defendant doesn't have to interact with Ms. Gates in order for him to see his child.
Okay.
Okay, Your Honor.
Okay. I'm going to order a $4,000 signature bond through pretrial. I'm going to order that there be no further contact with Satonia Gates. I'm going to order a stay away from the 540 Humphrey Street. I'm going to order if there's any visitation with the son that it be facilitated by a third party. Order a one-time return with law enforcement to retrieve any personal items. I'll order no drugs, alcohol, or weapons while on bond. And I'll order the one-day anger awareness course. And I think that's it. Anything else I need to take up?
No, Your Honor.
No, Your Honor.
Okay. All right, do we have anyone else? I think we have three.
We got position number one,
And one.
Mr. Adefema Way. Wow.
Wow.
Your Honor, this was also supposed to be conflict attorney, which our conflict attorney manager could not contact any conflict attorney. So this has to be done tomorrow as well.
All right, I will reset this case till tomorrow, February the 10th.
No, Your Honor. I'd like to represent myself in lieu of my attorney.
I would like
strongly,
really strongly advise you against representing yourself because of your right to remain silent. Anything that you state about the facts or occurrences of this case can and will be used against you. The state is here listening. And I think that,
I understand that, Your Honor.
I'm sorry?
Should I understand that, Your Honor?
And against those admonitions, you still want to represent yourself and go forward with this bond hearing
Correct.
without the advice of counsel?
Yeah.
Okay. All right, we'll go forward. This is case number 22 CR 000642D. You're charged with one count of battery family violence. The offense date was 12/12/2021. Pre-trial.
This is fifth arrest. Last arrest was back in June. DUI, fleeing an officer, serious injury by vehicle. That's open in Superior Court. 21 CP 200-706. A 2012 battery that was NOD'd, and an arrest out of Oklahoma from 2004. Failure to pay on underage in bar/package store. Assault and battery and public intoxication. I don't see a disposition.
Okay.
But he got the open felony in Superior Court.
Okay.
Yes, Your Honor, this incident occurred on December the 12th, 2021, at an incident location of 1000 Park Avenue, apartment 1011, Atlanta, Georgia, around 7 a.m. Atlanta Police Department did respond to a dispute call, and they were met with the victim, Miss Trier Harris, that's Trier Harris, common spelling, or Trier Harris. And she informed the officer that the defendant punched her in the face following an evening of arguing. The defendant and Ms. Harris are husband and wife, and they do share a child together and reside together at that incident location, Your Honor. The arguments actually started earlier in the evening at the Blue Flame Lounge, where the defendant became agitated that Ms. Harris was speaking to some of her friends that she saw that evening while they were out. When they returned home, another argument ensued while they were laying in the bed, and he got up and punched her in the face with a closed fist and caused a laceration on Ms. Harris's face, which the officer was able to notate. For these reasons, Your Honor, the state is recommending a $3,500 surety bond, a stay away from that incident location at 1000 Park Avenue, apartment 1011, Atlanta, Georgia. No further contact with Ms. Harris, no alcohol, drugs, or weapons, and a one-day anger awareness. Your Honor, the state is concerned with witness intimidation. Our victim advocate did get a chance to speak to Ms. Harris, and she did advise that she does not fear the defendant, and that they do reside together and have been married. And although the state understands that she would like for him to return home, we also understand that victims who are subject to domestic abuse are often swayed away from participating in the prosecution process. And the state is concerned that if the defendant cannot resolve whatever it was that agitated him, perhaps it was jealousy or envy regarding those friendships that his wife is maintaining, that if that should happen again, that he would resort to the same violence, Your Honor. And we would also like to notate to the court that the defendant does have convictions out of Oklahoma for assault and battery from 2004.
Speak on that.
All right. I see that my victim is on the call. Ms. Harris, would you like to address the court?
Your Honor, can I speak on that first?
Hold on a second.
Yes, I would like to address the court.
Do you want to go before or after Mr. Adewale?
He can go ahead.
All right, go ahead, sir. And pronounce your last name again.
Adefemiwa.
Adefemiwa, okay.
All right, so I'd like to mention the assault case from 2004.
You better be careful. You better be very careful. This is why I've cautioned you about representing yourself.
I'm being very careful.
If you want to talk about other cases and facts and occurrences, you're just going to use it against you when you get to court. You need to tread very lightly.
That's fine, Your Honor. All this is documented. The 2004 case was a case of self-defense. I was being pushed out of a vehicle, and
I don't want to hear about that case. It's not what's before me. If you have that charge or that conviction, as were you convicted of that charge in 2004 in Oklahoma?
I believe it was mentioned in relation to this charge, and I just wanted to mention that, that case is totally different from this particular charge. So
okay.
I don't understand.
I understand that based on the charge. Let's talk about this incident.
Well, I did not punch my wife in the face. And I'm really confused as to how this whole, the officer has this version of events, but I would like to, all I want to say is that I did not punch her in the face.
Okay. All right, Ms. Harris, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Tell me what you need to tell me about this incident.
So me and my husband, we were celebrating our birthdays together because we have the same birthday. And we came home and we had a little argument about something. And I was being very combative, and I was arguing with him and saying, really triggering things and hurtful things to him. And I was laying down and he was basically, I said something really hurtful, and then I was laying down, sitting up, and he tried to hit the pillow, but he hit me in my face. Yeah.
Okay.
So it was on accident. But I do not, my husband has never put his hands on me. We've never had this type of issue. I do not feel in danger when I'm around my husband. In fact, I feel safest when I'm with him. I feel like this was a really bad mistake and a bad choice for him. He helps me a lot with our kids, and I need him here with me because, it wouldn't work if it weren't the other way. And that's that, I wouldn't feel safe if my husband was not here with me.
How many kids do you have together?
We have 2.
What are their ages?
8 and 1.
Can I say just one more thing, Your Honor? Just one thing.
How old are you?
I'm 30.
No, Mr. How old are you?
I'm 36 years old.
Do you work?
Yes, I own a car rental company.
I didn't hear you.
I own a car rental company.
Okay. All right. You from Georgia?
No, I was born in Nigeria, but I've been in the United States for about 20 years now.
All right, one last thing.
Okay, I'd like to state that I'm 6'5", 300 pounds, and I'd like to state the obvious that if I did punched her, there's no record of EMT being called. There's no record of any medical attention being sought. There's no record of any injuries or major injuries or broken bones or anything like that. I'm a former football player, and I'd like to state that, if I indeed had punched her in the face, it would be documented in hospitals or there would be some type
Yeah,
of.
I'm gonna stop you there because you need to be very careful representing yourself. Some things may come back on you later, so I'm ready to rule because I can't do the what ifs. Okay, I just need to hear about the fact.
Yes, Your Honor, and I would like to note that it was documented that Miss Harris did have a laceration on her face at the time that the officer responded. It was in the middle of her forehead. And to my understanding, it was Miss Harris who contacted the police on that night on December the 12th, Your Honor. And again, it was also documented because the officer Livesey's body camera actually captured those markings on her forehead, Your Honor. So that is how the officer was able to charge the defendant, excuse me, Your Honor, with battery, because there were visible markings on Miss Harris at the time of the response call.
It was the next day. It was the following day. It wasn't when it happened.
And with that argument, Your Honor, with that additional fact, that tells as to the level of force that was used against Miss Harris at the time that the marking was still there, invisible, that next day, Your Honor.
All right. And so again, this offense date was December the 12th. And then he was not arrested until yesterday.
Yes, Your Honor, that's correct.
All right, I'm going to order a $3,500 surety bond. And I'm going to order that there be no further contact with the victim, Tria Harris. And if there's visitation with the children, that would be facilitated by third parties. And I'm going to order a stay away from the incident location, 1000 Park Avenue, apartment 1011. Mr. Adefenwa, and I apologize for mispronouncing your name, he may return one time with a police escort to retrieve any personal belongings. And let's see, no drugs, alcohol, or weapons while on bond. And I think that is it. Is there anything else, Ms. Webb?
No, Your Honor, there's nothing, no other conditions from the state, Your Honor.
Okay. All right, that will conclude this matter. All right, who do we have next, Deputy? Do we have position 3 or?
We have Mr. Banks. I don't even have the title for this position. Number 3.
Who was that speaking and what did he say?
Bobby Banks.
Okay. That's case number 22 CR 000646F. You charge it 1 count of criminal trespass. Offense date is February the 8th, 2022. Your job?
I'm gonna defer to the state.
Okay. All right. Ms. Webb, what do you have?
Yes, Your Honor. This incident actually took place on December 28th, 2021 at the Emory University Hospital located at 550 Peachtree Street, Northeast Atlanta, where the
The
defendant was.
the offense date I have is incorrect.
That is what I have.
They have on here February the 8th is the offense date for Mr. Banks, position 3.
Let me double check, Your Honor.
Okay.
I could be, yeah, I could be incorrect. So let me just double check.
No problem.
And oh, you know what, Your Honor, I believe this may be in a case where he has multiple charges, so it may be 2 combined. Let me see.
Okay, and you really got to help me because I only have 1 on the calendar, but.
Okay, let me double check.
There are 2, one on February 8, 2022, and then another one on December 28, 2021.
Yes, so there's 2 charges. Actually, I'm not for sure which charge of these is before the court, as both of them are for criminal trespass, but I do not mind addressing both.
I don't have both before me. I only have the one with February the 8th. The other one is not before me, to my knowledge. Is it, Miss Bridgewater? I think I just have.
Just show the one. I only have the one.
Right, from
And that's the
2000.
February 8th incident?
Yes, just the February 8th.
Yes, Your Honor.
Okay.
Okay, so let's see here. Okay, yes, Your Honor, this incident took place on February 8th around 3:30 a.m. at the Grady Hospital, Your Honor, located at 80 Jesse Hill Drive, Southeast Atlanta, Georgia. This incident took place where the defendant was asked to leave the property and he refused to leave even though he was discharged, and the lead nurse who was on staff and the doctor who was on staff did inform the security officers that they had discharged him and gave him his discharge forms, and at some point he became combative towards the hospital staff and they had to ask security to intervene, Your Honor. For those reasons, the state is asking for the court to honor that $1,000 surety bond that was already preset, stay away from that incident location at Grady Hospital of 80 Jesse Hill Drive, Southeast Atlanta, Georgia, and no alcohol, drugs, or weapons while out on bond, Your Honor. We do believe the defendant has a high risk of reoffending and a flight risk, Your Honor, as he does have that other case of trespass from December of last year, Your Honor, and as well as he does have several FTAs from 2003 and 2002. I know defense will say that those might be a little attenuated considering the dates, but there are a couple of gaps in the history that are explained by 2 convictions. One are non-disclosed, which was a 7-year sentence, and a second one for a cocaine with intent to distribute with a 10-year sentence, Your Honor. So for those reasons, we are requesting for the court to honor that $1,000 surety bond with the stay away and no alcohol, drugs, or weapons while on bond.
Your Honor, Mr. Banks is 48 years old and he was born here in Atlanta, Georgia. So he has a strong ties to the community because his mother and cousins are all here. He does not have any flight risk because he has a medical condition right now. His hip bone is needing special treatment because of his condition right now. He has a break that involves the head and neck of the femur intracapsular fractures. It kind of needs special medical screws and needles and rods and plates. So with that, I don't think he is eligible to fly right now. And also he really needs, Grady is basically his major place that he can go for medical help. If he gets to stay away from that particular hospital, he has no other place to go for his medical conditions. So we would like to request that if he has to stay away, it will be only when he does not have any appointments or any medical reasons to be there. Then it's okay for him to stay away. and he has no job right now. He has been washing cars until last month, but ever since last month, he does not have a job, and his education level is up to 9th grade. So he cannot make a bond payment at this point. So we would like to request for signature bond, and if you're not, your honor is not inclined to give him signature bond, we would like to request for $100 surety bond, because he cannot afford anything at this point, and he has 2 children even here in Georgia. So he's not going to be flying away anywhere. Thank you, Your Honor.
Mhm. Okay. Well, I am concerned, Mr. Banks. If you need treatment from Grady, you cannot be alleged to be abusive to them. So I'm going to order, continue with the $1,000 surety bond. I'm going to order that you have no further violent contact with any employees or persons at Grady Hospital. I will not order a stay away except for during the times that you're not being treated or have doctor's appointments. But if you are there for your appointments or treatment and you get violent again, you're going to be arrested. And that time we will order that you stay away so you won't be able to get any more treatment there. You cannot be abusive to them there for any reason, or you will be banned from there and you won't get any treatment. Looks like you may have had that with another hospital. So you're banking on not getting treatment anywhere in Georgia. You continue to be abusive to the people that work at those locations. At these hospitals. Be careful.
Mr. Banks, I strongly advise you not to speak on behalf of yourself right now. You have a right to remain silent, Mr. Banks.
You need to listen to your attorney, but I'm just going to give you that last warning. No matter how upset you may get or mad about something, you need to find a better way to discuss it and not become belligerent or offensive to the workers or employees at Grady or any other hospital or facility that you may be receiving treatment. So be careful. But anyway, you have a $1,000 surety bond, no drugs, alcohol, or weapons while on bond. And it is no further violent contact with any employees or workers at Grady Hospital. And you can only go there for treatment and appointments. Any other times you need to stay away from Grady unless you're receiving treatment.
So what's a surety bond?
You go through a bonding company. Okay. All right, that will conclude this matter.
Thank you, ma'am.
Well, I think that's it, Judge. So
Is that it?
Yes, Your Honor.
I guess we will let you go then.
It's position
I-
number 8.
bond it out. Bond it out.
Bond it out. Okay, thank
Yeah.
you.
Okay.
8 and
I'm
12.
gonna try to make this as fast as possible. Put your listening ears on, hold on, and let's go, okay?
Okay.
All
Yes,
right.
ma'am.
Again, the reset date for the SAP calendar is the 22nd of February, okay?
Yes, ma'am.
All right, let's go. Position number 1 is being reset to the SAP calendar with a $3,500 good bond. Position 2 is reset further notice with a $5,000 total SOB through pretrial. Position 3 is reset to the SAP calendar with a $1,000 good bond. Position 4 is reset to the SAP calendar with a $3,500 good bond. Position 5 is reset further notice with a $3,500 SOB through pretrial. Position 6 is reset to the SAP calendar with a $3,500 total good bond. Position 7 is reset further notice with a $5,000 SOB through pretrial. Position number 8 is being reset further notice. They bonded out. Position 9, reset further notice with a $4,000 SOB through pretrial. Position 10 is reset to the SAP calendar with a $3,000 good bond. Position 11 is reset to the SAP calendar with a $5,000 total cash bond. Position 12, reset further notice, they bonded out. Position 13 is reset further notice with a total $2,500 SOB through pretrial. Position 14 is reset SAP with a $6,000 total good bond, and the add-on calendar is being reset further notice with a total $6,000 SOB through pretrial. Are there any questions, comments, or otherwise?
I'm sorry, I do have a comment. So as you all know, the emails are down. Typically, we email our orders to everyone at the end of the calendar. How do you like to handle that?
Right. Well, I guess you can send them tomorrow, and then what'll happen is they will get them to me to sign. Yeah, because
Okay.
that's what was going on too. I was trying to get them through my personal email, and I understand Fulton County's having problems with that today. So just get them to us as soon as tomorrow.
Judge,
Yes.
do you have a fax number?
I don't have one anymore. At my house, I used to. But
Okay.
but you know, if I don't know if they have a way to get them to you, because I think they're not in the building. And you can ask Mr. Jordan if he has another way.
Well, that was his suggestion to fax them to you.
So we can't, the only way we can get them to you, Judge, is to scan them in. And the scan comes into the Outlook. So it doesn't give us an option to send it any other place. That's why I was trying to see if you had a fax.
Well, I could let you fax them to my other office, and then they can forward them to me.
Okay.
And I'll send you that other the other fax number.
Well, as far as the orders that the PDs have to provide, and I think the state has a couple of competency evaluation orders we need to present. I can only speak for myself, but I work from home, so I don't have a fax machine. So Ms. Bridgewater, is it okay if I email you tomorrow morning, or?
It is. It's, look, we're all in a jam.
Okay, I'm just trying to figure it out before we get to that.
Out of our control, so what do we do?
Right.
Yeah, so they'll just have to, and well, all of those, right, all of those are on surety bonds. I don't think they're gonna be bonding out tonight on those, right? I think the two, and the one is cash.
Yeah.
So I think we're okay. But Ms. Bridgewater will send over what she has. And then as soon as you can get them to us, you know, tomorrow, Mr. Walker, then they'll get them to me and we'll.
And do me a favor, when you send them over, send them to Michael Jordan.
Okay.
So he will have access and can continue the process.
Yes, ma'am.
Okay.
Okay.
So Michael.Jordan. Okay.
Exactly.
Yeah, we'll just do what we can do.
That's all we can do.
Yeah.
But we can't do this. Go home and just relax. Have a good evening, okay?
Yes, ma'am.
Oh, what is that? What is
As
that?
ordered by Judge Bridgewater, go home and relax.
Yeah.
Wow.
Bye.
Thank
Thank
you, Your
you.
Honor.
All right, thank you.
Be safe,
Y'all-
everybody.
Okay, bye-bye.
Judge Massey,
Yes.
can you send us your fax number?
Oh, duh, I forgot. I'll hang up and call you real quick.
Okay.
Okay, bye.